here to have a meeting of those kind of approaches. You know, and the other question, big topic was, county fair. The other topic was, well, when are we gonna own 56 Highway?
Oh, no.
That, city council member, we've been talking about that, and they're trying to get 199th Street. But of course, you know, this big old elephant sitting out here called a bridge or an overpass that we couldn't afford to upkeep. That's been what's stalling this discussion.
You can't, so I'm not gonna say you can't.
I know.
That's a US highway, that's a state
Oh, but they
highway.
wanna get rid of the state signification and turn it over to 199th Street, like the state would like to do.
Reroute
Someday, reroute.
US 56.
So that we have control of downtown.
And you start.
Video's on.
That's all right. I want people to know I'm frustrated.
You know, the problem is, instead of adding to that snowball, let's chip away.
Maybe they have been.
And I don't, you know, that's the problem, we need to chip away with what we.
All right, I will take this paperclip, and I will hereby call our meeting to order. Could we all please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. On our agenda is the roll call. Could we start to my left?
Kevin King?
Mike Hutton?
Kip Wilnauer?
Colleen Ward.
All right. And we have a consent agenda, but I'd rather just go through item 1 and item 2. Item 1, approval of October 6th, 2015 meeting minutes as written, and you saw those, have them here attached, and we also saw them on the website.
I move to approve as written.
Do I hear a second?
I'll second.
It's been approved and seconded, and all in favor say aye.
Aye.
All opposed, same sign, it's passed. Number 2 item on this is approval of the 2016 Board of Zoning Appeals meeting schedule and application deadline, and there's some concern that the city would like to bring to us.
It was brought to our attention today that we had some scheduling conflicts on this calendar. What you have before you is a revised calendar. If you'll look down the meeting date, the July and the September dates, we had to bump to a Wednesday. We couldn't go the following week on a Tuesday because court has the room reserved for those days, so we just moved them over a day. Those happen to be weeks that we have holidays, and the council meeting ends up being bumped to that Tuesday. So if, when you make your motion, if you would reference the revised draft 2016 calendar, that would be great.
Any discussion on that? I do. I won't be there for either of the Wednesdays.
That's okay. That's
Good
why
for
we
you?
have a vice chair.
I think, yeah, I mean, yeah, I think so, you know, you never know. Yeah,
Okay,
Shouldn't be a problem for me, 'cause I'm on.
right. Do I hear approval for the revised 2016 Board of Zoning Appeals meeting schedule and application deadlines?
I move to approve
I
as
hear a
revised.
motion. And do I hear a second?
I'll second.
And all those in favor say aye.
Aye.
All those opposed, same sign, it has passed. So the revised schedule has passed. New business.
Since I got you here to approve the calendar, I figured I'd, make it worth your time, more than 5 minutes. We're just gonna go over some, highlights of the, bylaws and just some reminders. Try to do this every year to make sure that we remember some of those important keys. I do have some copies of the bylaws if you would like one or need one. Let me know.
I think, don't we already have, or?
Yeah, Probably,
Okay, so
but
talk us
it's
through
up
it.
to you.
If you would.
Just some highlights. Let's see, going up here. Officers are elected annually in July. You have the chair, the vice chair, the secretary. The secretary is always, the city administrator or designee, which is technically Larry. Attendance, this is not addressed in, the bylaws, but it's addressed in the governing body rules of procedure. You do violate the policy if you miss 3 consecutive meetings without an excuse, or attend fewer than 2/3 of the regular or special meetings. We don't typically have a lot of issues with that with the board. The meetings are set annually, you just did that. Special meetings can be called by the chair or secretary for a fixed time and location. We have had to do those before. Always keep that in our back pocket if we need to. Quorum is a majority of the membership, which is 3. That's necessary to transact any business and take any official action. Continuances, any item can be continued or deferred, sometimes called, by the applicant or a recommendation by staff or a board member. Applicant is entitled to 1 continuance, and it's recommended that it be continued to a date certain. That way we can make sure that we have met all the publication requirements and everything, and that everybody here knows if the item is going to be continued to a specific meeting. And feel free to jump in and ask any questions if you have any. Appearance before the board, a public hearing for items that require. I don't know that you have ever taken up any appeal. Typically the items that you will see are variance requests, but this board would also see any appeals to the determination of the community development or business and economic development director. So if our office makes a determination on the code and that person wishes to get, to appeal that determination, that would come to the board for that finding. Typical meeting setup. Chair reads the agenda item, presentation by staff. We've tweaked this a little bit based on our attorney's direction. We did have the public hearing opening after the applicant's presentation. He has asked that we have you open the public hearing and then have the applicant presentation, just because that is then considered part of the public hearing portion of the meeting. In that public hearing, the applicant presentation is given, any public comments are given, and any board questions or comments. Close the public hearing with a motion and a second and a vote, and then board discussion, and then you have action, which includes a motion, a second, and a vote. Voting is typically done by voice vote. Your bylaws do say that you shall have a roll call vote if there are any dissenting votes. I think partially that way, especially on any recording, people can tell who's voting for what. All members, including the chairman, shall have a vote and shall vote when present. As far as your motions, you can make a motion for approval, denial, or continue or table an item. Every motion must receive a second. If a motion does not receive a second, it dies, and you will need a new motion. After a motion is made and seconded, you can discuss a motion, which includes amending it. It can include just clarification. Now, this is what you meant by this motion, correct? You can have all the discussion you want. The person who made the motion at that point, if they feel necessary, could amend it just to clarify it or to tweak it and such. And then once a motion is made and seconded, there needs to be a vote.
On I've got a do they have to withdraw the motion they made and then, like, don't you, is that what you're supposed to do if you?
You can amend your motion.
Okay, you don't have to withdraw? and
You
then-
don't have to withdraw, you
Okay.
can amend it,
Okay,
but somebody else cannot amend your motion.
okay,
You're the only one that can amend it or withdraw it.
okay.
It's abstentions, board member has a conflict of interest only. Don't abstain because you don't wanna make the hard decision. I know all of you have been a part of that, especially with the Perkins flag, that was very difficult one. And, you know, we wouldn't want anybody to abstain just because they didn't wanna make the unpopular or popular vote. That's what the duty of the board members is to make those determinations based on, the criteria outlined, in the staff report, and, it's hard to keep feelings out of it, but kinda gotta separate the two. If you do abstain, you must vacate your chair and remove yourself from the dais. Cross-communication, any communication between board members should, not occur. If you have any questions or anything, those should be directed to the chair. We don't want audience members and such thinking that you're discussing the, project before you amongst each other, even if you're just asking for a piece of gum or something. So, try to refrain from that. Ex parte communications, this is a big one, and it can be iffy. Ex parte communication is communication outside of the public hearing. Not all communication is, prohibited, but you need to be pretty careful about it. You will get people that come up to you in the grocery store and such. It's okay if you don't feel comfortable discussing the project to say, I appreciate you wanting to give your comments, please come to the meeting so everybody can hear that information. Or provide us an email with, that information so that we can make sure that everybody hears your comment and such. It's okay to turn people down, just, you know, do it politely. Encourage them to provide contact to everybody during the public hearing. If you do wanna listen to the people, disclose it in the meeting. I was at the grocery store and I talked with somebody about this project, this is the view that they shared, this is information they shared. Now you're covered. You disclosed it, everybody else knows the same thing that you, heard, so we're good with that then. So background quasi-judicial proceedings, this board is a quasi-judicial board. A group which has powers and procedures resembling those of a court of law or judge. Planning commission decisions are appealed to the governing body. Appeals to the Board of Zoning Appeals go to the district court. You have some pretty big powers sitting in those chairs up here. So it's really, a different kind of power.
Has that ever happened to you?
I don't know that it's happened here, not that I know of.
We've had a couple
Next court.
that, yeah, but they said they was gonna carry it on through, but they never, as far as I know, they never did. There was a couple of them that, well, they weren't satisfied, and they wanted to take it another step. I don't know if they ever did or not.
This is pretty hard to read. This is our variance application process. We have pre-application meetings with anybody that wishes to make application. We have the submittal deadline. We do public notice to, the newspaper, and we do send out notice letters to 200 feet, around the subject property. Staff then reviews the application, puts together a staff report, and then, you get the packet. We have the public meeting, which is what we are today with the public hearing, and then the final decision today. So they get final action today, they'll get a letter tomorrow saying, board met on this day about your project, this was the determination. And then if you wish to appeal that decision, this is your process. Or they approved it and you can apply for your building permit tomorrow. Depends on what it is, but we always send action letters so that they know what happened and that they have formal paperwork of that action. Speaking of actions, variances, this is what you see most often. Variations from standards in the code. One thing that you will not see is a use variance. That is not legal based on state statute. We cannot have somebody come in and say, I live in a residential zoning district, it does not permit a drive-through restaurant and I would like to put one on my property, I would like a variance. We can't do that. That is permitting something in a district that is not permitted. It's not a variation of a standard. And then these are the findings outlined by state statute. Findings that you'll see in our staff report, we go through each one of these and make what we call findings of fact. Staff finds that, and we go into, in the staff report, if you remember, if found yes, then it meets this standard. Or if found no, then it meets this standard. We have, and these tests are very hard to find. Condition which is unique to the property is not ordinarily found in the same zoning district and is not created by an action or actions of the applicant. That end part of the sentence is probably the big part. This one's really hard to meet. Variance would not adversely affect the rights of adjacent property owners or residents. The strict application of the provisions will constitute unnecessary hardship on the property owner. Money is not always a hardship. Excessive amounts of money could be considered an unnecessary hardship, but typically if you had what somebody would consider an unnecessary hardship, it also doesn't meet that first one, that it's something that they created themselves. So some of these kind of pair together. Variance will not adversely affect the public health, safety, welfare, morals, order, convenience of the community. Granting of the variance desired will not oppose the general spirit and intent of the zoning title. Those are what we're going to give an analysis of the project for. And like I said, these are pretty hard to meet, and there'll be times where the board disagrees with staff recommendation, and what we need to do is, if that is the case, if you are going to make a motion that is different from what staff recommendation is, we will ask you to go through and make your own findings. And what you can do is go through these handful of tests and say, I find that the strict application of the provision will constitute an unnecessary hardship because of X, Y, and Z. You need to make support for why you're voting the way that you're voting. Our staff report, those findings are laid out, and if you vote as the staff recommended, you can then say and adopt those findings. I recommend the denial of this variance based on the findings of fact in the staff report. So those are all laid out for you. Then you're adopting what staff has already done. If you're voting in a different way, you need to make your own findings to support it. And then that way, that will give, if they do appeal it to district court, it will tell the judge why you voted a different way and what standing you have, what you base that decision The other prong of your, options here are the appeals, which I had, told you about. The appeals of the board may be taken by anyone aggrieved by any officer of the city or any governmental agency or body affected by the decision of the officer administering the provisions of this title. You'll even see, sometimes different departments making appeals. You'll see a county or a city appealing a county decision. You'll see some of those internal struggles come out on some of these, that I've seen as far as case law and things like that. So, I don't know that we've seen any of these, so we're doing okay. That tells us that we're doing okay with interpreting the code and people are okay with it. And that is all I have. So if you have any questions or concerns or comments or anything.
I'll simply bring up the recent discussion of the newspaper and some city council members. Would you, just tell us who to talk to and who not to talk to, as far as staff?
I need background.
Background, like if I wanted to go talk to Michelle about something, is that proper or not? If I wanted to talk to the city administrator about something that we discussed, is that proper or not?
The way it's set up is that, each board or commission is staffed by internal departments. The governing body is staffed by the city administrator. And there's that relationship there. Our department, people that you see here, we are your staff. So you should be talking to us, where the council and the governing body should be talking to the city administrator. So that is their line of connection. We are your immediate line of connection. So please, talk to us.
As long as you're doing great, there's no need for discussion.
Do we ever meet, we never have, but I mean, would we ever meet outside or leave the room for a second or however where we would talk amongst ourselves without anybody else ever knowing what was going on, if we felt that there was a problem?
Like an executive session?
Yeah, some type of thing like that. Would we ever do anything like that? I mean, if we ever felt like that would ever come up where we needed to step out for a minute just to
Yeah.
to try to straighten something out amongst ourselves, can we do that or not?
I don't know that there's any provisions for you to have an executive decision, or executive session. Really, the executive session for the council is typically on land acquisition, personnel matters, and, really those are the two big things. And is there something I'm missing in there? And those are things that you're not really discussing, so it would be difficult to say what you would need to be discussing behind closed doors that you couldn't discuss here. But I would say that no, anything that you would need to discuss as a group needs to be done in a public setting
Yeah, nothing
during
like
a
that's
meeting.
ever happened, but I didn't know, you never know.
Yeah.
I didn't know if something like that ever come up where, well, somebody didn't quite understand. I guess we could work it out in here where somebody didn't,
Yeah.
You didn't understand.
Normally you would have a city attorney here, and if there was ever a time where you would need to go into or have a private discussion of some type, an executive session, you could certainly ask the attorney if there was any instance or provision for that, and then he could direct you as to whether or not there was such a set of circumstances. I'm not aware of any. That doesn't mean they don't exist. But the third one that that the city council can go into is things of legal entity. In other words, where the city attorney needs to discuss kind of the attorney-client relationship issues. For example, if the council needed to be addressed on an insurance matter or or some standing interpretation of law that they needed to be aware of before they made some ruling or decision. It could be that the city attorney might need to discuss that with them in some type of executive session. And that might be the only one I can think of, but even in that, in most cases, the city attorney is going to address you in a public forum. He's going to say, these are your options. But I wouldn't say there's never a case, but
Well, that's what I was going.
it would be very seldom.
Well, and then another thing would be kind of the other way around. What if we had someone that was trying to present something and, well, they needed to step, can we call a recess for them to get everything together? If they,
Mhm.
you know what I'm saying, like somebody's up there and then
They're under stress.
yeah, yeah.
Sure,
Can we call
Sure.
a
Sure,
recess?
you
Oh, yeah.
can, you can recess for a certain amount of time, and you can recess during a meeting
That's what I mean.
for a break.
Yeah.
Typically, if you're going to take a break, we would ask that you conclude an item. Otherwise, there's the risk of, even if you're not doing it, that if you're in the middle of an item and you leave, all of you leave, and you get to chit-chatting in the restroom, and then you come back and you make a decision, there's that communication outside of the public hearing. Even if it didn't happen, there's the perception that it did. So if you did need to call a recess for, you know, like your example, for somebody to really just kind of gather themselves and give them a few minutes, you can do that, but we would probably recommend that you just
Stay
kinda
here.
stay here.
Yeah, that's what I mean.
You know, there's other options that you could always, let that person sit down and let other people speak until they're, you know, ready and composed, and do things like that, just to give them some time, but still keep the public hearing moving, or things like that.
Yeah, every once in a while, of course, it had never happened very often, but a couple times it's happened where somebody gets a little rattled and,
Yeah.
you know, either they get mad or they just kind of fall apart, you know.
And I've given folks time to address and readdress, and, you know, so just be patient with me. I also have attended city council meetings where they've given me at least 2 times to address them about an issue, as well as others.
Yeah.
You know, so.
And that's really up to the chair. They're the one running the meeting and can kind of control that. You know, there's a balance for respecting everybody else's time too, and, you know, but also letting that person kind of get a hold of themselves, because it can be pretty daunting coming before a group and speaking, and especially when emotions are high, and, you know, these projects can sometimes be very personal to people's hearts, and it can be very difficult, so.
Well, how about a time limit? Can we if we have somebody that just decides that they want to be the north wind, can we tell them they have another 2 minutes to wrap up?
Sure.
Okay.
Sure. The planning commission bylaws, they actually have time frames set in. Is 5 minutes if you're representing a group, and I think 3 minutes if you're for individual, but then they have some leeway to be able to, relax some of those. You know, the chair, if you get somebody up here that's just going on and on and on, you know, the chair can go ahead and step in and say, you know, if you could wrap up your comments, please, there's other people, you know, kind of reel them back in and say, can you please wrap up your comments, and so we can take some action on this item.
Sounds like you know what you're doing.
They know what they're doing. That keeps
That's
us
the main
from
thing,
meeting
huh?
12 times a year. Anything else?
And of course, you can, if you have any questions, you can always give us a call.
Yep. All right, thank you. There be anything else? It's not on the agenda? Then do I hear a motion to adjourn?
I move we adjourn.
I hear the motion. Second?
Second it, or,
All in favor? That's All right, all in favor, say aye.
Aye.
Aye. It carried. Oop, there's my paperclip.
Here.
Hey, are you on city council?
Am I? No, I'm not. Is this me?
That's you.
It's a mistake.
Mistake?
I was just signing.
Now